Hi, a question we're often asked about is when do I need to have completed my property settlement with my former partner by? It's often the case that property settlements can resolve quickly, particularly with the help of a family lawyer like the ones we have here at Genuine Legal. But there are other scenarios where they do take months and if not years to resolve successfully. It is the case that every party to a property settlement matter needs to have genuinely attempted to resolve their split within a specified time period. The Federal Circuit and Family Court of Australia, for that matter, determines that for all de facto parties, the parties must have achieved their settlement within 2 years of separating, and for all married parties, they must achieve that settlement within 1 year of any divorce being made effective. If the two of you do not reach an agreement within that time period, the court requires you, before that time period elapses, to make an application to the Federal Circuit and Family Court to have the matter determined with their intervention. Failure to do so could mean that you lose your potential entitlements to part of the property pool. Incredibly important that if either of those dates are approaching for you, that you seek out legal advice about your options. Now, you might also be in a scenario, having watched this video, where you realise that those dates have lapsed for you. Important that now that you know, you do not acquiesce, you do not wait and see what your former partner will do, or simply continue to negotiate without the help of a family lawyer. Obtain that advice urgently, as you may still be able to apply and receive the relief that you are entitled to as part of your just share of any joint property pool to be divided, if your family lawyer is able to act quickly on your behalf. Certainly there are exceptions to those limitation periods. And for those reasons, it is similarly important that if you are a party who is hoping to wait out those limitations, that you consider obtaining advice from a family lawyer as to your level of exposure if your former partner were to make an application out of time, as a court does hear these applications and can be minded to allow these matters to proceed, even if you are technically outside of time in relation to that particular claim. So for answers to all those questions and more, feel free to speak to a family lawyer at Genuine Legal like myself.